My cordial greetings to Dr. Rama. I'm Anira Frank Peter, and today I'll be presenting the case of PP versus Fang Jin Zhong 2015 10 CLJ 628, a case that was heard in High Court of Malaya Shah Alam. The facts of case is that the accused and deceased worked at the same factory. On the day of the incident, the deceased was found murdered in the storeroom of the factory premise. SP7 further testified that he saw the accused and deceased being in the same storeroom. Therefore, the accused was charged under Section 302 of the Penal Code and hence disappeared. In this case, there were three witnesses, namely SP4, SP7 and SP11. SP4 was the Human Resource and Administration Manager of the factory who testified that the accused came into his office and said he had an argument with the deceased and as a result he stabbed the deceased. Second, SP7, an employee in the factory who testified that he was working at his workstation and he heard some noises coming from the factory storeroom. Upon inspection, he found that accused standing behind the deceased and the deceased was bleeding around the stomach region while sitting on the floor with legs crossed. He testified that he did not see anyone else in the room except the accused. Upon that, he informed about the incident to his two managers. The third witness is SP11, a pathologist. She testified that were three wounds inflicted on the chest area of the deceased and two wounds at the back, and the two wounds was caused and were the fatal wounds of the murder of the deceased. The issue in current case is that whether the statement of the accused to SP4, the Human Resource and Administration Manager, was subject to Section 24 of Evidence Act 1950. Section 24 of Evidence Act 1950 expressly states that a confession made by an accused person is irrelevant in criminal proceedings in four circumstances. First, when the confession is taken by inducement, threat, or promise. Second, proceeding from a person in authority. Third, in the course of the charge of the case. Fourth, to gain any advantage or avoid any evil of the temporal nature. The public prosecutor submitted that the accused had the intention of causing bodily injury to the deceased, in this case, which has caused the deceased death under Section 300, subsection C of the Penal Code. Whereas the defense counsel submitted that the accused was provoked when he inflicted the injury, and this was due to a sudden fight, and that he did not possess the necessary intention to commit murder under Section 300 of the Penal Code. Moving on to the judgment and the court's finding. The accused testified to the Human Resource and Administration Manager that he stabbed the deceased. The accused voluntarily testified to the manager when he was not under any compulsion to speak about the incident to the manager, thereby satisfying the first link under Section 24 of EA 1950, which states that a confession made by an accused person in criminal proceedings is irrelevant when the confession is taken by threat, inducement, or promise. In present case, the accused voluntarily testified. Therefore, the confession is not subject to Section 24. Second, the manager was not the immediate supervisor of the accused, and he was not a person in authority. The Human Resource and Administration Manager was not the immediate supervisor of the accused person, as the accused immediate supervisor was the Facility and Maintenance Manager. Therefore, The Human Resource and Administration Manager was not a person in authority, thereby satisfying the second limb of Section 24 is not satisfied. The second limb of Section 24 states that a confession made by an accused person in criminal proceeding is irrelevant when the threat proceeds from the person in authority. As Human Resource and Administration Manager was not the immediate supervisor of the accused, he was also not a person in authority. Under the circumstances, the statement made by accused to the Human Resource and Administration Manager was not caught by the prohibitory provision of Section 24 of the Evidence Act 1950. The words uttered by the accused to the manager that he stabbed the deceased as a result of an argument and consequently asking the manager to handle the case and that he would follow whatever was decided amounts to a confession under Section 17, subsection 2 of Evidence Act 1950. The court found that the statement made by the witness to read the manager as P4 was not caught by the prohibitory provision of Section 24 of Evidence Act 1950. Through tutorial presentation, I have also learned that Section 24 of Evidence Act 1950 is primarily subject to voluntariness, as Section 17, subsection 2 of Evidence Act discusses about confession in general. Section 24, Section 25, and Section 26 serves as a prohibitory provision to admit a confession as a valid admission under Section 17, subsection 2. Hence, Section 24 specifically submits on voluntariness. In event an accused has non-voluntarily admitted to a confession, Section 24 serves as a primary provision to strike out the confession of the accused. However, there are certain requirements that need to be satisfied, that is, the four limbs of Section 24. That concludes the presentation for today. Thank you for your time and indulgence.